Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to Legal Ease, the show that translates legalese into English. I'm your host, Yumna Bhana. Now, South Africa is no stranger to strike action, and we loosely refer to strike season, which seems to come around at some stage every year, and sometimes several times during the course of a year. In more recent weeks, we've seen some severe strike action in the mine industry, with various mine workers going on strike, and also the truck drivers strike, which and both these strike actions have been particularly serious, both in terms of the impact that they've had on the economy and the serious nature that the strike action has taken, with a lot of violence being perpetuated. What we're going to look at today is just to introduce the topic of strikes and a basic discussion on what a strike entails, what is a protected strike, what forms an unprotected strike, some of the rights that employers have in terms of strike action, and maybe some recent case law dealing with strike actions. With me in studio to discuss these issues is Suemaya Hanif. Suemaya is a colleague of mine from Edward Nathan Sonnenbergs, where she's a partner. She has over 8 years of experience, particularly in labor law, and deals with all sorts of labor issues, from dismissals all the way through to strike action. Assalamu alaikum wa rahmatullahi wa barakatuh. Suemaya, welcome to the show.
Wa alaikum salam. Thank you for having me on the show.
Suemaya, let's start off just by defining what constitutes a strike.
Well, a strike in terms of the Labour Relations Act is a partial or complete refusal to work, or retardation of work, or an obstruction of work by a group of employees for the purpose of remedying a grievance or resolving a dispute of mutual interest. And a recent amendment to the definition of strike in terms of our new Labour Relations Act is that a refusal to work voluntary overtime is now also regarded as a strike, whereas in the previous LRA this wasn't the case. Right. So in essence, there are three elements to a strike. The first would be the nature of the work. So, you'd have to identify whether it's a partial refusal or a retardation of work or obstruction of work. And obstruction of work would be, for instance, an example where employees are unpacking a truck, for instance, and are too slow in unpacking or pack things in an incorrect place so that it's difficult to find. Even though they are at work, they're still obstructing work, and that can be regarded as strike action as well. The second element would be, it must be a concerted or collective effort by the employees. You must bear in mind that one employee cannot strike. It will be pointless. And that's why they refer to a strike as a collective action. And then the third element is that there must be a purpose to the strike. So it has to be a grievance coupled with it, or a dispute of mutual interest.
All right, just coming back to that. So when we're talking about, I think a lot of us might have experienced, these sort of go-slows at grocery stores where the packers are being just unnecessarily slow and all of that. That would constitute a strike action.
Yes, that would, because it is a retardation of work. Even though the employees are at work, they're just working at a slower pace. You'd often find go-slows in the public sector, for example, with your state attorneys. Because you wouldn't really find them out, on the street striking, so they would opt for the go slow.
All right, which is often difficult to tell from their normal work. Now, the other thing you mentioned is that there must be a grievance or a dispute that has a mutual interest for both the employer and the employee. Mm-hmm. What does that mean? Maybe just give us some examples of what a grievance might be, as well as what might be of mutual interest.
Okay, let me first give you an example of a grievance. A grievance would be, for instance, where a group of employees are unhappy with the disciplinary action taken against another employee. That would amount to a grievance. Another grievance would be, for example, where an employee alleges some sort of discrimination. But that won't necessarily be result in a protected strike, and I'll deal with that later. A mutual interest, a dispute of mutual interest, in essence, it is an issue which an employee wants to have a right to. He wants to have an entitlement to, which he currently doesn't have. So he will use strike action in order to get that. So it normally the guide would be a guideline would be, is it something that can be subjected to collective bargaining, this issue? And if it is, then it's most likely a matter of mutual interest. And our courts have given that definition quite a wide interpretation. So you can have a vast variety of issues that an employee wants to raise with the employer, wants to obtain as a right. For instance, a wage increase. Currently the employee has a right, he gets a certain amount, but he wants a higher amount, and then that would result in a matter of mutual interest. For instance, a certain company doesn't provide medical benefits to an employee, and that they seek that right, they will refer that as a mutual interest issue. And for instance, health and safety issues, they may, for instance, your miners, they may state that their shifts are too long, and as a result, they want a further 15-minute break. That would be an issue of mutual interest. So, those are the types of things that you would look at as a dispute of mutual interest.
Just as an aside, are there any specific things that come to mind if you think of something that employees might strike about that wouldn't be of mutual interest?
Well, for instance, there's such a thing as an unlawful demand, for instance. And that would be where an employee or the employee's demand that a specific employee be dismissed without following proper procedures. So that is unlawful. Because you have to follow the law, you have to give the employee a fair hearing. That demand would be unlawful, and the strike would be unprotected as a result. So that, it may be a matter of mutual interest, but it's an unlawful one.
So, just before we go to the break, I think you've started introducing the issue of protected versus unprotected strikes. Let's look at very briefly what a protected strike is, and we'll continue that discussion after the break.
Okay. A protected strike A strike would be protected if it complies with the requirements in the Labour Relations Act, or if it follows or complies with the prescribed requirements in a collective agreement. So in essence, the procedure in terms of the LRA, it requires a group of employees or union acting on their behalf to refer a dispute to the CCMA or a bargaining council that has jurisdiction. And the CCMA will then appoint a commissioner. The commissioner must then conciliate the dispute, and if it cannot be resolved, he must issue a certificate stating that the dispute cannot be resolved.
Let's leave it there, and we can continue after the break.
Okay.
After the break, we'll look a little bit more detail at protected strikes and what that entails, and introduce the topic of unprotected strikes and some of the actions that can flow from unprotected strike action. Stay with us. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease, where we are talking about strikes and what constitutes an unprotected strike and what constitutes a protected strike and some of the rights attached to these actions. With me in studio, I've got Suemaya Hanif, a colleague of mine from Edward Nathan Sonnenbergs. Suemaya, just before we went to the break, we started introducing what a protected strike is. Let's just continue with your explanation on that and go a little bit more into that discussion.
Okay, I start by saying that the CCMA will appoint a commissioner and a certificate of outcome will be issued declaring that the dispute is unresolved. Thereafter, the union or the employees may issue a strike notice. But there's also an alternative. If the employees or the union refer a dispute to the CCMA and a period of 30 days have passed from the date they've referred the dispute and the matter has not been conciliated, then the employees can elect to issue a strike notice at that stage as well. So there's those two situations that can arise. Just to deal with the strike notice, the Labour Relations Act specifies what the strike notice should be. It should be in writing and what it should contain. It should actually state when the strike will commence. Now, our courts had occasion to determine a dispute relating to a strike notice. There was a particular case where a union issued a strike notice and it didn't specify the actual time that the strike was to commence. The Labour Court found that you can't adopt an overly technical approach. As long as it's in writing and they've given 48 hours of the commencement of a strike, that's sufficient. But the Labour Appeal Court found when it went on appeal that you have to be specific and state the actual time, especially in instances where the employer operates on a shift system, because you need to put into place proper arrangements to ensure that if the employees are not there, that you have some alternative to deal with it. And on that basis, it was found that the strike notice was invalid. So that's something interesting to note.
Is there any requirement for the notice, or at any point in time, for there to be an indication of how long they estimate the strike action to run?
No, there isn't. They don't need to do that. That's not a requirement, and the strike will end when the dispute is resolved, essentially. So it's a matter of power play. How long the employees can hold out without a salary, and how long the employees can take that.
There's no stipulated maximum period for a strike?
No.
Right.
But with regard to a strike notice, once a strike notice is issued, the employees have to embark on strike within a reasonable period. And for instance, our courts have held that 1.5 years is unreasonable.
But to issue a strike notice and then just to
wouldn't
not proceed with the actual action. All right. Now, we often see a situation where a particular union or particular group of employees embarks on strike action, and then you've got unrelated unions or industries also going on strike, and in support of the primary striker. I'm going to call them the primary strikers, or the primary strike action. Is that a legally recognized strike?
Yeah, you call that a secondary or sympathy strike, and it would normally be a group of employees who belong to a different employer who go out in support of the strike in respect of the primary employer. But, there's certain procedural requirements there as well. The primary strike must be protected, so the requirements in terms of LRA must be complied with for the primary strike in order for the secondary strike to be valid. And the secondary strike, the employees who want to embark on it have to give 7 days notice to the employer. And lastly, the nature and extent of the strike in respect of the secondary strike, it must have some effect on the primary employer in order for it to for the employees to embark on it.
Okay. So where I say it's unrelated, it can't be completely unrelated. It's got to have some sort of flow of impact.
For instance, this current the truck driver strike, you had the employees at the port who wanted to embark on a sympathy strike, and there is a relation. Okay. But for instance, if the miners being on strike and the bus drivers being on strike in support of that, there's no.
All right, there's no nexus there.
Yeah.
All right. Let's move on to the next thing, which is an unprotected strike. When does a strike become unprotected?
A strike would be unprotected if the requirements of the LRA are not complied with. So from a procedural point, the strike would be unprotected. And for instance, I also mentioned a collective agreement may have a certain procedure that needs to be followed prior to an employees referring a dispute to the CCMA. If they don't follow that procedure, the strike would also be unprotected then. And there are certain instances where there are certain limitations on the right to strike, and those limitations would also be used to interdict a strike. So what you would do, I would deal with those limitations later, but in order to declare a strike unprotected, you would then have to approach the labour court on an urgent basis, and you would need to make out a case that the employees have not followed a proper procedure, for example, and that would be your clear prima facie right, and that you have no alternative remedy but to approach the court for relief on this urgent basis, and that you're suffering irreparable harm as a result. And once you obtain such a court order declaring the strike unprotected and ordering the employees to go back to work, you need to serve that order on the employees, and if the employees don't comply with that court order, then you can always approach the court for a contempt of court order against the employees.
All right. So that basically brings us to what rights the employer has where there's an unprotected strike. So these are the types of action that they're going to take.
Yeah.
After the break, we'll talk about unprotected strikes, more on employers' rights in terms of unprotected strikes, and we might look at what the position of employers is with respect to protected strikes as well. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease. We are talking about strike action, and just before the break we started going into unprotected strikes and what an employer can do in the case of unprotected strike action being launched against them. With me in studio I've got Suemaya Hanif of Edward Nathan Sonnenbergs. She's an expert in labor law. Suemaya, you were mentioning some of the rights that an employer has where there's an unprotected strike and what sort of action they can do to then stop that strike or prevent the action from continuing. Besides those that you've mentioned, what are the other rights that attach to an employer in that situation?
They can institute disciplinary action against the employees for participating in an unprotected strike. They could also approach the labor court for an order seeking just and equitable compensation for any losses that they may have suffered as a result of the strike. You must bear in mind that the labor court is a court of equity, so they're not going to get the actual loss suffered. There has been a previous judgment where an employer sought something in the region of 15 million rand worth of damages, but the court awarded 100,000 rand. I think as sending a message out that if you participate in an unprotected strike, then you run the risk of being awarded compensation against you.
Right. And in terms of a protected strike, and we were just talking about this during the break, there's basically no rights that an employer has to make that strike go away, other than resolving the issue that's at stake.
Yes, it boils down to power play. Who falls first is what will end the strike. So normally the employer will sort of make some, enter into some negotiation with the union or the employees.
All right, and just to clarify, in the case of a protected strike, irrespective of how long that strike continues for, those employees are entitled to their normal benefits, their normal salaries. There's no deduction that can be, of any benefits, etc. Is that the position?
Well, you see, if they're on a protected strike, they're not tendering their services still. So, they won't be entitled to pay.
Okay.
But you can't deny them their benefits for that period. I would assume it would be a bit unfair.
All right.
Yeah.
Okay. What are some of the limitations on a right to strike? Where can you not strike or shouldn't be striking?
The limitations on the right to strike, the LRA deals with certain instances, and this will form the substantive portion of your application to interdict a strike on the basis that it's unprotected. So, for instance, if the issue is something that's regulated by a collective agreement, for instance, with regard to the strikes that you see now in the mining sector, those employees are subjected to a wage agreement that's valid for a certain period. And in terms of that wage agreement, they can't go on strike until the end of that wage agreement, until the wage agreement terminates. So those employees are participating in an unprotected strike then, because they have to wait for the termination of the wage agreement before they can refer a dispute, which they haven't. The other limitation on the right to strike is where there's an agreement which provides for the dispute to be referred to arbitration. So where you have an alternative remedy, you need to follow that. So you can't strike in respect of that. And remember that rights disputes are arbitrated. This is a mutual interest dispute. It's not a rights a strike would be a mutual interest dispute and not a rights dispute, and that's why you'd strike on it. There's a third requirement. In terms of the LRA, there's certain matters that must be referred to arbitration or to the Labour Court for adjudication. Those you can't strike over as well. And lastly, those employees that are employed in essential services, like, for instance, the SAPS or medical services, can't go on strike, and your what we call maintenance services. But a maintenance service would be something that would be regulated by collective agreement. And it would be, for instance, services that would cause irreparable harm or destruction to the business of a company. So those are the limitations. Okay.
Now, we have seen it with one of the mine strikes where the mine actually fired the entire body of workers, yes, from what I understand, for participating in what was an unprotected strike. Is that a right that an employer has?
Yes, that is a right that an employer has. An employer cannot dismiss an employee who is participating in protected strike action unless that employee has committed some sort of misconduct during that protected strike, like assaulting other employees, for example. And an employer can also dismiss for operational requirements during a protected strike or unprotected strike.
Okay, which would basically be a retrenchment.
Retrenchment.
I'm
Yes.
assuming the normal procedures for dismissals would have to be followed
Yes.
in both cases.
Yes, you'd have to give an employer a fair hearing and allow him to make representations before you make any decision.
All right, so now I know there's been a recent constitutional court judgment relating to strike action. Just explain to us some of the merits of that case and what the outcome of the judgment was and what sort of impact that has going forward.
Okay, the recent Constitutional Court case related to a group of employees who were not members of SATAU, who joined a strike that the SATAU members had participated in. And what the employer did is it took the view that these employees should have issued a strike notice and should not have simply joined the strike. And on that basis, they dismissed them for participating in an unprotected strike. The matter then went to the Labour Court, and the Labour Court found, yes, the employees were unfairly dismissed. They need not have given us a strike notice. The Labour Appeal Court agreed. The Supreme Court of Appeal disagreed and said that a separate notice should have been issued because the employer needs to know and put into place mechanisms to deal with this. But then the matter went to the Constitutional Court, and the Con Court there found, like the Labour Court and Labour Appeal Court did, that there's no need for a strike notice to be issued. That would sort of be a limitation on these employees' right to strike in essence. And the fact that the majority union issued the strike notice, the demand is the same, and the outcome would affect these employees as well, that they could participate in strike. Now, the effect of that is any employee, as long as the demand relates to them, can then simply join a strike. And, we could even have a situation where management even joins a strike, provided that the demand is broadly phrased. So, for instance, if the demand is simply increasing wages, any employee can join that strike and demand that they get a wage increase.
Suemaya, just as the last thing, some while ago there was a judgment which awarded damages against one of the trade unions in terms of either an illegal gathering or a strike where damage had been done to various properties, as we often see in our strike actions. What exactly was the position there, and has that set a precedent going forward for damage that is caused by these other people who are gathering or striking, whatever the case may be?
Yeah, in that instance, the union had organized a march in the public space. And in order to do that, they need to comply with the Public Gatherings Act. And if they don't put into place proper mechanisms to ensure the safety of the public, and in that instance there was substantial damage caused, then the courts have stated that they would be responsible for those damages, and they were ordered to pay, and that has now set precedent. So unions have to be careful that they comply with the Gatherings Act if they want to have any public gatherings, and that they must make sure that their members behave, essentially.
Suemaya, let's leave it at that for today. Thank you so much for taking the time to be with us in studios.
Pleasure. Thanks for having me.
Well, I hope you've benefited from today's discussion and you've gained a better understanding of what strikes entail and what rights attach to various situations depending on whether the strike action is declared to be protected or unprotected. Please don't forget to send me emails on legalese@itvnetworks.tv and follow me on Twitter @Yumna Bhana. We look forward to seeing you again next week. Assalamu alaikum wa rahmatullahi wa barakatuh.